SJC-12026, Derek Washington v. Peter St. Amand.
Thank you, Fran.
Mr. Washington, do we have you there?
Yeah. Hello. Hi, how's everyone? Is it time for me to begin my argument?
We're doing just fine. We'll hang on one second and make sure, is that as loud as it can be? Okay, so keep your voice up, Mr. Washington, so that all of us can hear, and you have 10 minutes for your argument, sir.
Yeah, sorry. Yeah, I'm on speakerphone, so I don't know how clearly you guys can hear me, but I can hear you guys pretty clear.
Yeah, you're good, you're good. You're good, we can hear you very clearly.
Okay, so whenever I'm allowed, I'll proceed.
Yes, you may proceed now, sir.
All right. First, I would just say this is an extreme honor for me to be before this honorable court today. And I want to thank you all for your time and attention to the matters of discussion, as well as just allowing me this unique opportunity to be heard. So thank you all. This hearing today is a result of a civil action I initiated in the district court alleging Eighth Amendment violation, specifically deliberate indifference in regards to DOT defendant, nurse practitioner Maryville Gagliani, and for her failure to conform to accepted medical standards with in deference to the Massachusetts statute 231 section 60B. She motioned the district court to have her case remanded for a medical malpractice tribunal, which was subsequently allowed. Following the district court's remand, a medical malpractice tribunal had convened and, to my surprise, decided that no question of liability existed. I immediately pursued review of their adverse judgment because I genuinely felt that their judgment was in error, and I was curious to learn what exactly were the factors weighed in rendering that judgment, especially given the overwhelming amount of evidence I presented, which is apparently why I have gained you all's attention here today. However, I noticed that the defendant does not challenge or address anywhere in her reply brief opposition to the claims listed in my brief, in which I assert that a legitimate question of liability does exist, and that the tribunal's judgment was error. So I won't lose time in attempting to further a point of argument in which the defendants have not contested. So moving along, it appears, though, that the subject matter of the hour, in which I have been called to argue, is the 10th Amendment issue concerning state and federal jurisdictional boundaries in lieu of cases held in diversity. So to get directly to the issue, the defendants argue that I have no right of appellate review within the state, and that any appeal from the tribunal determination is governed by federal law and resides with the federal court, not the state. In addition, they assert that there was no error of law or abuse of discretion by the single justice. Well, I beg to differ. Since 1789, the cornerstone of our democracy, at least for the most part, has been geared towards fundamental fairness. Yes, I am indigent, and yes, I have been denied the right to post a reduced bond, but I will argue, though, that the legislator's intent in enacting 231 section 60B was specific in stating that if said bond is not posted within 30 days of a tribunal's finding, that the action shall be dismissed. And drawn from language of Paris, first Connolly, a case that the defendants used, decrees that it must be dismissed with prejudice. Unfortunately, after dismissal, our legislators did not leave us with any clear path for us to pursue review of a prospective error or abuse of discretion by a single justice, which is where I believe the beauty of common law comes in to offer some guidance, invoking the authority from LaFawn versus Casey, and mellifluously segueing into cases like McMahon versus Glicksman, which basically states, yeah, go ahead. You can appeal an adverse judgment without first posting the required bond amount, but upon finality, if it does not pan out to your favor, don't think that you're going to come back and get a second bite at the apple, meaning that judgment is final and possibly even fatal. I would even argue that these same rules apply to federal cases held in diversity, in which the Rules of Decision Act, garnered from Section 34 of the 1789 Judiciary Act, do apply, commanding that federal courts recognize the state's decisions, at least where there's no conflict. Furthermore, question 2 of Austin v. Boston University specifically states that federal courts should not fashion their own tribunal, which is the very reason why also the doctrine of present execution applies here, and that appellate review is collaterally linked to the state appellate process. The fact of the matter is that, as emphasized in Erie and its progeny cases, that the state statute prevails when there is no conflicted federal authority, which would mean the language in Glickman is absolute. Look, Erie v. Tompkins overruled Swift v. Tyson to bring about more order to our federal system by attempting to discourage forum shopping and doing away with the inequitable administration of laws. The defendants cite Erie, but evasively fail to answer how, by allowing me appellate review in the state, will it prejudice them? They can't answer that question. Why? Because by the defendant's motioning the district judge to remand their case to the medical malpractice tribunal is within itself a reverse practice of forum shopping, in which by allowing me appellate review would be antagonistic to the whole tactic of a one-and-done, sudden-death type of strategy in which they've espoused to. Only because they know chances of further appellate review in the federal court system following an adverse tribunal judgment is highly unlikely, simply because the standard of liability up there is deliberate indifference, whereas in the state, it's only negligence. So if I'm unable to pass the tribunal in the state, then it's very doubtful the federal court would even entertain further adjudication. That's why 231 Section 60B is substantive law, and interlocutory review is collaterally linked to preserve the substance of the case. So by allowing me state review, I believe would prevent this reverse practice of forum shopping. I would even argue that future defendants would think it over before motioning the district judge to have their case remanded, if they were aware that all cases held in diversity would be afforded due process of interlocutory state review. And defendants who risk being exposed to a strong likelihood of liability may even resolve to avoid a tribunal altogether and take their chances with summary judgment to circumvent any possible harm that will come from an unfavorable written appellate court or SJC opinion. In conclusion, I request that this honorable court, if it finds jurisdiction to be in the state, retain its power pursuant to General Law, Chapter 211A, Section 10, and to not only review and decide the present issue, but also to review and decide whether the medical tribunal's findings were erroneous, rather than this court deciding to remand the matter for appellate review back to the appellate court. This court has the entire record of the tribunal proceedings before them, and the defendants have had an ample opportunity to file response to the issues as well, but they chose not to. So this request is being sought in the interest of judicial economy and finality to prevent a prolonged appellate process if circumstances at least come about. And finally, to address the elephant in the room, or probably over the phone, yes, I am incarcerated and deeply entangled in this web of the 13th Amendment. Our prisons breed these sort of conditions that create these situations, which is why criminal justice and prison reform is definitely needed. The prison experience has taught me that human beings are not incorrigible, and I will argue that life without parole sentences are not consistent with the integrity of our state or the evolving standards of human decency within our country, in which a true emancipation initiative is past due. With that, it was truly an honor, and I thank you all for your time and attention. It's a pleasure. Thank you.
Thank you, Mr. Washington.
All right.
Mr. Wygand, we'll hear from you. And Mr. Washington, can you hear Mr. Wygand?
He hasn't said anything.
It's still on, I trust. Okay. Please proceed.
Yes, thank you. On behalf of the respondent, Mary Jo Gagliani, RN, Mr. Washington's petition should be denied for three reasons, one of three reasons. The first being that any appeal from an adverse tribunal decision of a case pending in federal court is a matter of federal law and federal question. Second, there was never any operative notice of appeal. And third, even if there was a failure to process in state court his appeal, any error was harmless error, as the offer of proof was insufficient as a matter of law.
Can I just ask you, how does this work from here? So he filed the notice of appeal, and it wasn't processed for reasons that are not so clear. And the appeal was dismissed, right? So the appeal was ultimately dismissed in state court. And you say ultimately that's not a problem because the federal court can just hear it again? I'm not really appreciating why the federal court would do that.
Okay. Starting from scratch, there was, this was filed in federal court. It was because of a
Right.
negligence claim, it was referred to the Superior Court for the purposes of a tribunal only. That tribunal was held. The offer of proof was found insufficient.
Yep.
He then filed a motion to reduce the bond. That was denied. He then filed a notice
Denied by the Superior Court judge or denied by the federal judge?
by the Superior Court judge.
Yeah, so why was that even before the Superior Court judge, if your theory is right?
Because I believe that anything incidental to the tribunal is heard as part of the referral. But as far as any jurisdictional order, as far as any dismissal, as far as any operative judgment from which an appeal could be taken, that stays with the federal court.
What does? You're saying everything having to do with the medical malpractice tribunal stays with the federal court? I don't understand this.
No, everything, when it's referred for a tribunal, if the issue as to the bond reduction would be addressed by the judge on the tribunal.
Okay, and I thought he was appealing from the denial of the motion for bond reduction.
It's a good question. The only notice of appeal that was filed only referred to the tribunal, didn't make any reference to the decision on the denial of the reduction of the bond.
So you're saying that if he had, that would have been something that should have been heard by the state courts?
If he had filed a notice of appeal from the
Denial of the motion.
motion of the bond, any appeal would be with the federal court. It's for the federal court to determine as a matter of federal law the appeal. Look, at a right to appeal from a tribunal that's referred from federal court and a right to appeal from a decision on the motion to reduce the bond is a substantive ruling, no question.
So could
But
he have
that
gone
has
to
be
the
with
federal?
court.
Could he have gone to the federal court to get the motion to reduce the bond?
He could have. Well, that hasn't been decided, but I believe that the motion to reduce the bond should be before the Superior Court judge on the tribunal. The issue before you is where do you go for the appeal on a reference case? And we're saying that there's no jurisdiction for any appeal. It resides with the federal court. So once there's a ruling on the tribunal, once there's a ruling on the motion to reduce the bond, if it's denied, and if the person is aggrieved, the findings of the tribunal are then referred to the federal court, which was done the day after this tribunal, and any appeal is then addressed as a matter of federal law and a matter of federal question. This court touched upon this in the Austin case, Austin versus Boston University Hospital back in 1977. There were certain certified questions that were referred to this court, one of which was, what do we do with the tribunal process when a medical malpractice claim is filed in a court other than the Superior Court? This court was very careful in addressing that question to say, we are not going to be dictating, we do not presume to tell a federal court how to implement or apply the medical malpractice tribunal in a federal case.
But at this point, the federal suit's been dismissed, isn't that right?
No, very importantly, Your Honor, it's a good question. It is still ongoing. There are other defendants, and so the last review I saw on the docket is there are the other 1983 claims against the correctional defendants is still ongoing, and it's before
But
Judge Wood.
your client's suit is also still alive?
Well,
I mean-
there's been no, the federal judge dismissed the claim for the failure to post a bond, but I didn't see any separate or final judgment. No judgment has been entered, which would trigger a right to appeal under federaal process.
So what's his next step?
So his next step, as I say, and I don't believe he's been deprived of any right to appeal, is he's been taking all his attention in the state court. He should be going back to the federal court and asking for review. Now, Judge Keaton addressed this in the Pazzalula versus Rucker case, a 1984 decision. He addressed the question of, it was a federally filed case referred to a tribunal, and some of the defendants wanted to appeal. And so he was faced with the question, well, where does that go? Does that go to the First Circuit? Do I address it? Now, there was no argument that the appeal should be with the state court, but it was argued, does the trial judge of the federal court first hear the appeal, and then the First Circuit once an appropriate judgment, or is he required to issue a dismissal and then only have it heard by the First Circuit? And he looked at it, because he was bound by Erie, and he found and concluded that the right to appeal from a tribunal decision that's referred is a substantive right, but it's guided by federal law and federal procedure. And he decided that the first layer of appeal would be with him as the trial judge, because the First Circuit probably wouldn't look fairly on having to review a matter that hadn't been touched upon by a federal judge. So, but the import of that decision is that the right of appeal is governed by federal law and is a matter of federal court to implement.
Let's just talk for a moment about what the appeal would be. So you're saying that the appeal, as you understand it, has to do with the tribunal decision and not the request to reduce the bond. Is that right?
Based on what he's done in this court.
That's your understanding?
Correct. The only thing that was filed was the notice of appeal, and it didn't reference the decision on the motion.
Nonetheless, a Superior Court judge denied the request to reduce.
Correct.
Do you believe that Mr. Washington could go to federal court and ask that the bond be reduced?
He may be able to. I'm not sure I can answer. I think he could. I think his first endeavor should be to request that review, whatever review he wants. There hasn't been a separate and final judgment.
And if that were denied by the federal district court judge, do you have any reason to think that that couldn't be reviewed by the First Circuit?
No, none whatsoever. Again, Judge Keaton addressed it in that Palazzula case and felt that the process of appeal would be first to the district court judge himself, and then at the appropriate entry of judgment upon conclusion of the case, or separate and final, it would go in front of the First Circuit. So I don't believe he's been deprived of any right to appeal. It just hasn't been presented to the federal court for determination pursuant to federal law.
But either way, the Superior Court judge shouldn't have dismissed it.
Correct. I don't believe.
There's nothing to dismiss.
Right. I don't believe the Superior Court had any jurisdiction to issue a dismissal. It even, in fact, I think in June of 2015 issued a judgment. I don't believe it had the jurisdiction to do that. The jurisdiction was to hold a tribunal, transfer those findings, and any right of appeal and process of appeal would be a matter of federal law.
And with regard to the medical malpractice tribunal, was there any expert affidavit that he submitted as part of the medical malpractice proffer?
He did. And just to address that, Your Honor, Mr. Washington was involved in an altercation in the prison with correctional officers. He had to be restrained. I believe a chemical agent was used. Nurse Gagliani was called to evaluate him at the scene. She evaluated at the scene. He had some lacerations. She wiped certain lacerations. He produced an expert RN at the time of the offer of proof. Where it was deficient was, while he identified certain deviations, like you didn't bandage certain lacerations on my foot, and I was dragged through the prison, exposing me to germs and hepatitis A. He had deviations identified like that, but the offer of proof was deficient because it did not address in any way causative or injury beyond mere speculation. There was just no identifiable injury as a result of this alleged failure to properly assess him at that scene. So for those reasons, I suggest that Mr. Washington's petition be denied.
Thank you.
Thank you very much.